Supreme Court not announcing whether they've taken Illinois' case challenging gun and magazine bans across the state, as the Southern District of Illinois sets a bench trial date. We've talked about that, but yesterday, of course, we were waiting to see if there was going to be any announced order list from the U.S. Supreme Court, and that did not happen. It's Bishop on Air. I'm Greg Bishop. Thanks for hanging out. The state of Illinois enacted a gun and magazine ban back in January of 2023 in federal lawsuits filed shortly after. You have cases in the Southern District and the Northern District go different ways. The appellate court said that the state had a likelihood of succeeding. Plaintiffs then asked the U.S. Supreme Court to come in while the case proceeded elsewhere and try to take the case on a preliminary basis, while the Southern District of Illinois said that they are going to expeditiously adjudicate this case on the merits. So while the U.S. Supreme Court did not announce that you've got the case being taken up and it's got individuals on the Second Amendment space like Chuck Michel saying nothing from SCOTUS, and the 2A cases pending cert today. Thursday becomes the day to watch for a ruling in Rahimi case, and next Monday for action on the 2A cases from Illinois, semi-auto and mag bans, and New York, sensitive places abuses. So those are just some of the things that are going to be watched by the Second Amendment community. And Hannah Hill, somebody we've talked with quite a bit on this program, she shared her thoughts on the issue, and she, of course, is from the National Association for Gun Rights, sharing what it means with the U.S. Supreme Court's no listing of the Illinois cases.
Hey, y'all. So this morning, the Supreme Court once again took zero action on our case challenging Illinois' assault weapons ban. Our team came in early. I've got my coffee here. We were hopeful that this might actually be the day we would get news on the case from the Supreme Court. We had our fourth conference last Thursday, and the orders came out this morning from that conference. This isn't a hard and fast rule, of course, but we did note that Bruin was granted after its fourth conference. So we are now heading for our fifth conference. First off, no news is always good news, because any day the Supreme Court doesn't reject our case keeps alive the possibility that they could ultimately grant certiorari. And that is what we're hoping for. There is certainly the possibility that they keep relisting it because someone is writing a denial from cert, and that they're going to reject it as soon as that is finished. That's certainly a possibility. You're going to see a lot of speculation on that. But the reality is, no one who's not in the room actually knows. And we're all speculating. We're all looking at the statistics and everything, but we don't know. And we won't know until the Supreme Court actually does something. There's also the option that the Supreme Court is waiting until after they issue their Rahimi ruling. We've been hopeful all along that they would provide some clarification on how to apply Bruin's tests, especially in light of how uniformly the lower courts are trampling it for the most part. If they do that, then they could issue Rahimi and then reverse and kick back a lot of the Second Amendment cases that are now pending and say, all right, now go back and do what we did here. Follow our instructions here. A go and do thou likewise kind of ruling. Assuming Rahimi is what we hope it will be, that actually wouldn't be a bad option. So right now, we hope and we wait. The South Carolina motto, that's my home state, is while I breathe, I hope. And until the Supreme Court actually takes action, that is what we are doing.
So again, Hannah Hill from the National Association for Gun Rights, providing a bit more context. I chatted with Thomas Magg. He is the attorney for the Langley plaintiffs in the consolidated cases in the Southern District of Illinois Federal Court. Again, the Southern District, below the appellate, below the Supreme Court, the Southern District is now addressing the case on the merits, whereas the U.S. Supreme Court is being asked to take the case on a preliminary basis. Thomas Magg talking about no SCOTUS announcement on the Illinois cases from yesterday.
Well, I see it as a good sign that we haven't been rejected by the U.S. Supreme Court. Of course, the overwhelming majority of cases that certiorari or an appeal is sought to the U.S. Supreme Court are just summarily rejected just because of the sheer volume of people seeking Supreme Court review. So the fact that they've relisted it several times, in my mind, is a good thing. and it's similar to what they've done in prior Second Amendment cases that they have taken. So I remain optimistic.
So in my conversation with Mag yesterday, asked about what it means for the trajectory, the path for the Southern District of Illinois federal case.
A bench trial has been set. The parties have been proceeding, getting ready for that bench trial. If the Supreme Court does not take it, which of course is a possibility, then I'd say the odds of us going to trial in mid-September are right at about 99.9%. If the Supreme Court does take it, we'll probably know this month. And I simply don't know what Judge McGlynn would want to do. There's arguments both ways of either proceeding and staying, regardless of if the Supreme Court takes it. But I think the Supreme Court has a good chance of taking it, and I think there's a good chance that if it does, we won't go to trial in September, although we've got to prepare for it as though we are until we know otherwise.
So, again, moving forward in the Southern District's court about the merits of the case. And there's hundreds of pages filed by the state from their experts. I asked Mag for his assessments of those reports.
The general takeaway is that the state's experts wouldn't know an M1 carbine from an M1 Garand. They've got a lot of experts that simply have opinions on things that are irrelevant to the Bruin test. Yes, firearms are capable of hurting people. That's what they're designed to do in combat and for self-defense. Self-defense results in people getting injured sometimes. But the fact that a firearm potentially functions correctly or functions as intended does not mean that you don't have a right to possess it. And the state's experts seem to think that the AR-15 is some super lethal killing machine that it imposes grievous wounds beyond all proportion. I wonder whether any of them have ever taken an old 30-30 deer hunting. The wounds from that kind of round are far more egregious than anything a .223 round will do, which is generally full metal jacket and designed to wound and leaves a minor wound. I mean, it can kill, yes, but that's not the issue under the Bruin test.
So clearly some interesting arguments expected during the bench trial. September 16th is when that is scheduled. And Mag said he and other plaintiffs are going to continue on as if that bench trial is going to happen.
That the plaintiffs are preparing to proceed on September as scheduled unless the Supreme Court takes it and the court decides to stay it pending that. We remain optimistic. My opinion, and I think the opinion of all the plaintiffs' counsel and the plaintiffs, is that the Illinois ban is unconstitutional, and we look forward to having it declared so.
So we'll be watching this, of course, but yesterday wasn't just a day where people were watching the SCOTUS order list. You had Moms Demand Action holding a Gun Sense University event, and Illinois Lieutenant Governor Juliana Stratton was there. Here's something that she posted on her social media from yesterday.
And we know that there are too many people, and I say this as a woman of faith, too many people in elected office think that thoughts and prayers are enough. And I am someone who believes in prayer. That is my faith. But my faith also tells me that faith without works is dead.
So clearly a lot being said from the gun control advocates, even after the weekend was a Wear Orange weekend to raise awareness about quote-unquote gun violence. But I think even Illinois State Police put out a statement about that, wearing orange to raise awareness about gun violence. These are things clearly we'll continue to watch as we watch the trajectory of these cases and the path that they go. And will the U.S. Supreme Court take them? Will the Southern District continue on for a bench trial? And how all this plays out in the courts. All right, it is Bishop on Air. Like, subscribe, hit that notification bell. Appreciate you guys being here and join the program.